Madam, I follow Marcus.
Yes. On the last occasion, we remember.
Yes.
You had informed this bench that you don't want to appear before this bench. What do you have to say about that?
No, my lord, we are all humans. There are two popular sayings. One is attributed to Alexander Pope, and the other I do not
don't want to hear that.
You don't know. There are two things. The here is human. My lord, to forgive is divine. The other is rare is humanum, perseverare et diabolicum. So, my lord, here is human. So, my lord, I cannot be a judge of myself. Nobody can be a judge of himself. So here is human, my lord. That is completely past. Let us look forward for a nice things. Nothing. I tell you, my lord, I defended, my lord, when your lordship's valuation came.
Mr. Nandurba, I don't want to hear that because you have mentioned that earlier. I don't want to hear that.
Yes. So I will. When my lordship may forgive me for saying that, when I come to your lordships, I always, when I said young lawyer, because one of the first.
You are not young anymore.
No. No. Yes, when I 45 years before, I attended the course in 1979, 46 years before. Then the first book, one of the first books I read was, Malad, that is, Roses in December. And that book, for me, borrowed by Justice, he was a lawyer then, Pius Kuriakos, he retired as Chief Justice. So that book, Malad, I lost that book, Roses in December. So, Malad, that Justice Chagla says, he was with the junior of, the Muhammad Ali Jinnah. For 30 years, he was not paid a single fine. Process in December, I read it in 1979. So, therefore, wherever we go in Kerala, we used to say, there's a great judge in Bombay, MC Chagla.
Yes.
So, therefore, I would like your lordship also to be known as MC Chagla.
Yeah, anyway, continue. Yes.
I got a melody to save the court's time. Every lawyer's duty. So many matters are pending here. And therefore, I follow the teachings of Marcus Fabius Cundilianus. Marcus Fabius Cundilianus. Cundilianus said if there are 10 contentions, you're the greatest lawyer. But if one contention is good enough, stick to that. And I do that. In actual practice, I do that. So that much of time is saved.
Yes.
And
I think we should follow that.
Yes, very well I follow. And I, to the extent possible, I never take any judgments. Because statutes are clear. And I rely on the notification.
This list of dates, madam?
Yes.
Have you given him a copy?
Yes. Yes. No issue. Now, the only contention I raised, the 2060, etc., I am not raising it. Yes, the only convention I raised, I am protected by the notification. Yesterday, I wanted to take your lordship to section 29. What happened was one page was missing from my book. Yes, that is why I was in, page 15. Page 15 of the application. Just pass. Your lordships have the book? Yes.
When is the registration of the entity of the petitioner as an MSME?
MSME, it is at 5th of September 2019 at page 36.
And the NPA was prior to that?
There are many, the NPA, they have classified the account of page 36. Page 36. They classified NPA at least 3 times. So I may not understand details, I don't have to trouble your lordship. They classified as NPA, then I made some payment, then again they made me an NPA, then I further made payment, again made me NPA. So that those all are may not be very strictly required.
So when was 13-2 notice issued?
13-2 notice was issued on 22nd of August 2022. That is at page 78.
78?
Page 78. 78, right? So what is the page number? Page number.
22nd of August 2022.
Yes, the paper fully is not Yes, I see.
That is what I am submitting. My
Yes.
lord. The latest 13.2 is of 21/10/2024. He's not relying on that 13.2, but
No, rely on that. If I made a mistake, I'll correct you, no? Yes. If I made a mistake, I'll
Possession
correct you.
notice which he has
Yes.
annexed. He has annexed the earlier 13.2, my lord, because the loan account whenever the account turned NPA, I have mentioned that in clause number 5.
We will go by what you say. No, no facts, no issue. Yes. Yes.
My lord, permit I can produce that.
Yes, because I am being briefed by the client is a widow. So there are limitations. She was not doing business husband. Now, I take your.
But then if the 13.2 notice,
Yes.
which is subject matter
Yes.
of this writ petition,
Yes.
is not in the writ petition,
It is there, isn't it?
where have you mentioned it? How do we then consider your arguments?
No, not why.
Because you've not even annexed a copy of the 13.2 notice.
No, there is no difficulty at all.
Page number they have annexed, my lord, which is earlier.
Yes.
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 So are you challenging the earlier 13.2 or the latest?
No, now they say the other steps are the section 13.4, possession notice. Williams had made a reference. I read it in 1978, 79. Yes. So now your lordship will find.
Can you just tell us,
Yes.
in your petition, have you made a mention of the 13.2 notice dated 21st October 2024? In the body of the petition, is there a reference to the 13.2 notice?
No, my lord, my submission is, my lord, I can overcome that difficulty. I can overcome that
Well,
difficulty.
you just tell us whether it is made or it is not made. Then the question comes of overcoming.
It is not made. It is not made. It is not made. I find it here. Because she is a widow.
She will not, Mr. Nidumbara, she will not know what is there in the petition.
No, I know.
She
But
is not a lawyer.
because some of the documents she brought today. Some of the documents she brought
You
today.
want leave to amend.
No, now. There is no difficulty. So there is no. That is not no way affect my case really. I take this, your lordship, that will not affect my case.
All right.
That will not affect my case. So all that, my lord, now a subsequent stage has come whereas same notice has been issued. So, my lord, if my convention is
Same notice is
under section 13.8 of this, my lord, the same notice 13 option notice under the security of the rules.
Where is it? Which exhibit?
That is produced in the interlocutory application. So nobody has a case that they are not acting under the inbox surfacing. Yes.
But we should know the document.
Yes. See, when I, she's a widow, she got some documents today only. I just sent her to take photocopies. Yes. At page 8.
Page?
8, exhibit 8, page 8.
Page 8.
Yes, of the IA number 27940/2025. Your lordship, that's in a separate IA. IA.
My lord, there is no bids received with regard to this, but then the issue in this petition, my lord, has already been covered by your.
What is this document?
This is the same.
This is a sale notice.
Auction notice. Yes, auction
This
notice.
is what they have annexed.
When is the auction taking place?
No, my lord, there are no bids received. Yesterday was the time,
It was on 24.
24.
Now, Mr. Nedumara,
Yes.
can you satisfy the court that under this notification of the MSME,
Yes.
there has actually been some steps taken for registration or what has happened?
Now, the briefest was two things. I'll follow continue and also what part from your lordship was. To be very brief. Very brief to take as little time as humanly possible. If your lordships, once I find your lordship understood my case, there's no question of me explaining. Yes. All that I take your lordship the notification only a few paras of the notification, page 70, my lord, page 70.
Yes. The 2015 notification.
Yes, yes.
We read that notification.
Yes. So therefore,
So we know it.
now the notification, there are two mechanisms for invoking the constitution of submit or resolution. One is, may I take your lordship to only 2 seconds. 2 seconds means not literally 2 seconds. Yeah. Para page 70, para 2. Page 70, para 2, my lord, that notification.
Yes.
Read it.
Your lordship, sir, I have it. Yes. Identification by enterprise. The lordship got it, identification by enterprise. Any micro, small, or medium enterprise may voluntarily initiate proceedings under this framework if the enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts and before the accumulated losses of the enterprise equal to half or more of the entire network. So if suppose I am a literate MSME, assuming that I apprehend a failure, and in that case, I can on my own make an application. Support para 3. Application for the initiation of the proceedings under this framework shall be verified by an affidavit of the authorized person. So if I apprehend, I identify incipient stress, I can make an application. So that is the stage where my account has not been in default for not more than 31 days.
Yeah.
If my account has been in the default for more than 31 days, then my lord, there's a duty is cast on the bank to create SMA account and make an application. I take your worship to a few lines above, there's a chart. Your lordship will find SMA 1.
Have you applied for initiation?
No, myself, I don't have to apply. And I cannot apply.
Just see 1.3.
Yes.
You are pointed on the notice.
Yes.
The application for initiation of the proceedings under this framework shall be verified by an affidavit of authorized person.
Yes. If I apprehend, if I'm a literate.
No, has that been done?
No, that will be done. No. That has not been done. By all cases, there is no need to apply. But it was there in 2000, it was there in 90s. A long chain of notifications I take your lordship through.
So what you are saying is that under this notification, the primary duty is on the bank.
Yes.
And whether you apply or whether you don't apply, but
Yeah.
under rule 1 or
Yes.
under 1(3),
Yes.
the bank is not absolved
Yes.
from exercising its primary duty and doing the
There
classification.
are not when I can apply real situations. So that is the case of the chartered accountant Anisha. She's a chartered accountant. She applied many months before. Bank will initiate, my lord, I think of constituent committee when it come across any of the signals of incipient stress. That signals of incipient stress is given in the RBI notification. Yes, this is the yes. Yeah. Yes. Up to the stage. The notification which I am referring is produced here, right?
No, what are you tendering?
No. RBI has given a long line of circulars saying how to identify incipient stress.
No, that's fine.
No, one second, Manoj. I'm not taking time. Yes.
We are recording your submission. We noted your submission.
No, no.
That the bank.
Manoj, I take a very, because one way or another it affects thousands of MSMEs. Therefore, I'm taking little time. May I take this book, Manoj, it contains all the notifications. And I'll be taking as the time. If keeping always in mind, reminding myself, yes, the first time is precious. Then, my lord, the first guy, what was the combination? The combination, the first circular I produced is dated 16/1/2002.
You have to go according to the notification under the MSME.
Yes.
Now, that notification is page 17.
Yes, yes, yes.
In 17, there has to be an identification by the.
Yes, that was, if your lordship want me to take that, I will take that first.
No, there has to be an identification that you are.
Yes, my lord. My lord, I take your lordship to page 65, the RBI guidelines. Everything is RBI guidelines only, page 65.
65 of?
This paper book.
Petition.
Petition, right? Okay, not just paper book. Okay, petition, yes. Yes, petition. Yeah, page 77, page 77. This is the RBI guidelines issued by the RBI in furtherance of the notification dated 29/5/2015.
Correct.
Yes, at page 77.
77.
77.
Yes.
SMA 0. Signs of stress. Illustrative list of. Yes, I got it, page 77. Yes. Illustrative list of signs of stress for categorizing an account as SMA 0. If I read anything, I will be doubling your lordship. I am only reading paragraph 3, which everybody, common people like understand. Return of 3 or more checks. Then increase in frequency of overdraft, borrower reporting, return, so many things. And then these are the illustrative list of signs of stress. Then, Lord, I take your lordship to the paper book of the notification, page 8, only 1 second, this book, only one.
Only one notification.
Only 1 second. Yes. Page 8, starting with page 1. This is the guidelines for rehabilitation of sick and small scale industrial unit. That is getting. Page 1 is the headline. The title,
Yes.
guidelines for rehabilitation of sick small scale industrial unit. Then page
2002.
Yes. I'm saying that the long.
Yes. We will take your word for it, Mr.
Yes. Page 8.
We will not doubt it. We will accept your word.
Page only fraction of a second. Page 8. Your lordship, page 8. Page 8 of this.
Yes. Appendix 1.
Yes. What that I'm saying that the policy of the government, the legislature,
Was there 15 years before 2015?
Yes.
Circular.
Yes. The heading is appendix 1. Illustrative list of warning signs of incipient sickness that are thrown up during the scrutiny of the borrower's accounts under the related records, etc. This long list is there. So RBI has been the guardian of the MSMEs under this scheme. And your lordship, I am not taking your lordship, this book also contains many other enactments which are supportive of the MSMEs. So therefore, the banks are required to identify incipient stress. Now everything is electronic.
Yes.
If my account is in default in 31 days, the computer will show me that plan. Then, therefore, I take your lordship to notification again at page 70. I take as little time as humanly possible, page 70 years. Then paragraph 1. Paragraph 1. Page 70 of the MSME, page 70. Identification of incipient stress.
Yes.
Before a loan account of a micro, small and medium enterprise turn into a non-performing asset, banks or creditors are required to identify incipient stress. create an SMA account, then make an application to the committee. Now, assume a situation where the bank fails to notice the incipient stress. Scenario, the third scenario. First I apply, second bank is duty bound to, the bank identifies incipient stress. The third scenario is I did not apply, bank failed to identify incipient stress. Third scenario is SMA 0, SMA 1, sorry, SMA 1. Principal or interest payment overdue between 31 to 60 days. I'm in default. SMA 2, principal or interest payment overdue between 61 to 90 days. I am in default. When I am in default, and bank will certainly know I am in default because the system will tell.
Computer will tell them.
Yes. And when the computer tells you I am in default for 90 days, immediately the account is classified. Maybe they may classify after a day or two. It happens in life. So therefore, once there is a default, my account has to be, they have to go to SMA and make an application, consider a committee and make an application to the committee. Now this is in principle in a law book. In reality, not a single bank or financial institution in this country created a single committee ever. Nobody has given effect to this notification. I have been raising this issue from 2016, this notification, because I had a small role to play in even this notification coming into existence. Part of some of the representations on behalf of the MSMEs were prepared by me. And there is one more contribution I have. I don't think I'm praising my own thing. Under the Motor Vehicles Act 166(3), as a young lawyer, I made an effort, and because of that only today, I suffered an accident in Assam. I am living in Kerala, I can file a suit in Kerala. Otherwise, the concept is less sickness, less cause, less risk. Where the plaintiff resides, that concept is never ever accepted. So, Motor Vehicles Act, because that was the reason, when the incident happened, somebody in the northeast suffered an injury. And to conduct a case, he has to travel all the way to northeast. So,
Can he come back?
Yes. So, therefore, my lord, now,
just one thing.
Yes.
Now, the petitioner was declared an NPA in which year?
Now, my friend says he has been declared as an NPA. I go by what my friend says. My records are different. I go by what my friend says.
My number 5.
Yes.
At the bottom.
Yes. My friend, my friend says yes. 21/10/2024. Yes.
The last time that you went into NPA was 21/10/20.
2024. Yes. And my client, she said because her husband was running the business, so she was not that fully aware of those things. She left me today also. She brought some papers now. So therefore, my lord, the MSMEs are financially illiterate. That's the major concern. Yes. Now,
No, just before that, in 2015, he had an NPA.
Yes.
Petitioner was.
I paid, my lord, 30 lakhs. Then thereafter I paid 60 lakhs. Then I paid 50 lakhs.
So then that.
I kept on paying. Therefore, they regularized my account. Again declared as NPA. Then again declared as regularized. Again declared as NPA. Yes, this is an happened. Yes.
Now the issue is that since the petitioner's account has been declared as NPA, prior to it being declared as NPA, did you take any steps under the notification?
No, I did not take any notification because
because under the notification one.
I'm under no duty. There are no obligations. This give me. Is to reach out the page. These are the pages. 2000 financial literacy. 92% is the financial literacy. MSMEs are illiterate. Financially illiterate. See, my lord, look at that definition. Micro, Yeah, now only the government became, they extended the benefit to medium industries. Otherwise is SSI units. I take your worship to the definition.
December 2020, you were classified as a MSME.
Yes.
Yes.
Now, the look at the section 7. Yes. Number page 36. Page 36 initially, I registered as Udyog Aadhaar, page 36. Then the name changed. Udyog Aadhaar became, I think, Udyam. The name changed at page 36 bottom. The page 36 bottom. Yes. Page 36 bottom.
Yes.
It is, the date of registration is 31/1/2017. 2017. And now may I take your worship to 1 second, one second.
No, so your date of registration
Huh.
as a small
Yes.
enterprise
Yes.
under the MSME
Yes.
is 31 January 2017.
Yes. 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 May I take your worship to section 8 of the Act? 1 second. Section 8 of the Act, page 8. Section 8 of the Act.
Yes.
Because, yes. Section 8. Memorandum of the Worship Government, page 8. Memorandum of micro, small, and medium enterprise. Any person who intends to establish micro or small enterprise may, at his discretion, or a medium enterprise engaged in providing or rendering services may, at his discretion. A medium enterprise engaged in manufacture or production of goods pertaining to any industry specified in the first schedule of the Industrial Development Regulation of Act of 1951 shall. So the what is mandatory is for medium enterprises engaged in the manufacture or production of any industry specified in the first schedule, not everyone.
Yes.
In the file a memorandum of micro, small and medium enterprise, etc. Justice Chandulkar, actually, I read out it, but your lordship somehow did not take notice of that. In one of the cases, relief was rejected on the ground that I did not register as an MSME. So that is because I should not be misunderstood. A long line of judgments. My case is so simple. But all long line of judgments were against MSME.
Let's not digress.
No. Yes. Now, therefore, my contention is, I am under no obligation to apply. This scheme is
Understood.
It's a preventive.
Now, can we just ask you one?
Yes. Any question? Yes.
So, there is the 13-2 notice that you have annexed to your petition is an old 13-2 notice.
Yes.
Admittedly, the bank has not proceeded on the basis of that 13th notice.
Yes.
Because the bank has subsequently
Yes.
given you a subsequent 13th notice,
Yes. Yes.
which is not there in the
Yes.
petition.
Yes.
My question to you is there a reply that you have filed to the 13th notice? Let us,
No, that is not. What she says that she paid money and
let
tells
us
him about
consider,
Yes.
let us
Yes.
consider the 13th notice which is annexed to the petition
Yes.
at
Yes.
78.
Yes. No, my lord, that is only a minor
So the
issue.
question is there a reply that is given by you to this 13-2 notice? Forget about the new notice. I'm asking even about
Yes,
the old
yes,
notice.
yes.
Have you filed a reply?
Yes. Yes. This is, going to tell. One second, my lord, one second, one fraction of a second.
Because in your petition,
Yes, no, fraction of a second, because I shouldn't be giving a wrong reply. Give me a fraction of a second. A fraction of a second, yes.
no, you will not get the answer in the petition because I have read the petition. In the petition, you will not mention anything about a reply.
Yes. There is a letter at exhibit O, page 83.
So I am coming to that.
Yes.
That's not a reply. I am coming to exhibit O.
Yes.
So there is no reply to the 13th notice.
Yes.
Correct?
I am unable to.
So all right, if you are unable to answer, therefore the answer has to be in the negative.
No, you didn't. Where? No.
We had filed a rejoinder.
Yes. May I take your lordships to, yes. Now your lordship is asking whether I gave a reply to the 13-2 notice or not. Yes. There is, my lord, your lordship will find there's a rejoinder I have filed. Yes.
Rejoinder.
Yes.
How can you give a rejoinder?
We had filed reply to that reply, we had filed rejoinder.
Who's given?
Sadi joined.
But there can't be. How can there be a rejoinder if there is no reply?
Reply filed to the bank,
No.
so we had replied to
I am
that.
not asking about the affidavit in reply.
Yes.
I am asking a simple question.
Yes. Yes.
Is there a reply given by the party in response to the 13-2 notice? Okay, let's proceed on the basis there is no reply. Look at exhibit O at page 83.
Yes.
Ray Projects is the private limited.
Yes.
All right. Now, who is the signatory over here, the director?
That is new time, right?
So at this point in time, the correspondence was exchanged by the
Yes.
widow person who you are referring to,
Yes.
and not the original husband.
Yes. In
Correct.
2000.
And 2015.
Huh? No, you she only gave.
All right. So therefore, let us presume that at least by this time,
Yes.
your client was aware of what is happening. Because she is making an application asking for further facility.
Actually, somebody is healthy.
That's all right. So therefore, when you are making an application to the bank asking for further facility,
Yes.
surely you know what the facilities are and what the record is. Only then you can ask for further facility.
Namalod, you must, what the RBI has informed you.
We'll go to RBI later. I'm just first, our facts should be clear.
Yes.
So therefore, exercise 2024,
Yes.
correct?
Yes.
October 2024.
Yes.
Your client was aware that there were 13-2 notices issued,
Yes.
but there was no response to 13-2 notice. Instead, your client went and asked for further facility. Now,
Yes.
before this request for further facility, Exhibit O,
Yes.
on 2 days after,
Yes.
there was a subsequent 13-2 notice issued.
Yes. That is, she has not
Not
gotten a
annexed.
notice. Yes.
Which you've not annexed to the petition.
Yes.
Which then resulted in a 13-4,
Yes.
which then resulted in possession notice, etc.
Yeah. But one bit I say, my lord. Yes.
My question is,
Yes.
at any point in time, prior to this, in response to all these notices issued by the bank, have you filed a response telling the bank, look, I am MSME.
Yes. I take your lordship to be. No. There is.
The question is not whether there is a dispute or no dispute. The
Yes.
question is in response to the notice.
Yes, I take your lordship to the
Of
letters.
MSME.
Yes. Not difficulty. Yes.
Or MSME under the 2015 circular.
Yes. The view that communication. Yes.
Because in your petition,
Yes. No,
Mr. Nedumbara,
Yes.
instead of saying yes, in the petition, you've not mentioned anything about this response. Why?
No, I have very clearly stated I am an MSME and to the benefit of the
I am
notification.
not asking, there is no dispute that you are MSME. The question that the court is asking you is,
Yes.
in response to these notices issued by the bank,
Yes.
have you told the bank that I am MSME and I want to avail of 2015 circular?
No, I communicated to them even before the notice is
I am
issued.
not asking about before, Mr. Nedumbara.
Yes.
After. The question is after the notification. Is that after notice, the party has to bring it to the attention of the bank, saying that I am an MSME and therefore I want to invoke the circular of 2000.
No, that is not the scheme. The scheme is what the letter and spirit of the notification is.
Yes, but Mr. Nedumbara, unfortunately, we are the High Court.
Yes.
The Supreme Court lays down the law and says that this is what the interpretation is. We can't go against that.
No, I take your lordship to the existing correspondence. Existing correspondence. There is the letter. Yes. Show me that. Yes. I may take your lordship to page 37. Page 30. Yes. Yeah. 38. 38. Yes. May I take your lordship to page 38? Page 38. This is a communication dated date of my petition.
There are so many documents that you are filing. So
Page 38.
yes.
Yes. This is a 5 October 5th of 2019. It's little not very legible. 5th of October 2019 at the top.
Yes.
That's what it is. Yes. This is to the chief manager, and it is paragraph 3. There's no numbering in the paragraph 3. Your Lordship got me? Further, Your Lordship got me? Yes. Further, as our second collateral is also now released, in spite of several requests made to you, and we are registered with MSME. A copy of certificate attached herewith. We kindly request you to reduce our interest rate accordingly as per MSME registration, as a new rule is recently framed by the Ministry of Finance for special consideration. People only know so much.
Yes.
They do not know.
Mr. Nedumbara, that is not the same thing as saying that you take steps under the notification.
No, the whole scheme is intended to help the illiterate MSMEs.
Understood.
This is therefore it is not that what they call let's secure it ignorantly. No, the court all law came from wrong only. We cannot deny that. Let's secure it. Your Lordship says Rastrikata. Where it came? Rastrikata came.
There's only two words. It
No.
everybody knows it. The Latin word that you are talking, unfortunately, we are not.
Sometimes we have to use the academic rules. Prasiddicata proveditate accipitor come from Ulpian. Ulpian, just one. Ulpian lived in 2nd century. Yeah. This is Everest must stop. Yes.
That's okay.
Yes.
Then Ulpian said, Prasiddicata facit ex albo nigrum, ex nigro album, ex recto garbum, ex garbo rectum. So, the reason is the law did not grow beyond 6th century after the Justinian. And the Senate of law is the 2nd century. It is not my opinion. There's a Frederick Pollock, there are two Frederick Pollock and Frederick Waytan.
Yes, back to this. Unfortunately, there are so many matters on our board.
Yes, only one minute. Frederick Pollock in his essay, I forgot the title. Frederick Pollock says that the law was at Senate, classical law was at Senate during the 2nd century, and after 6th century it went to the barbarianism. Yes. So now
we recorded.
Now your worship will find. Let me. So there was. I am somebody, an MSME, who is under no obligation to.
We've recorded that.
We are under no obligation to inform them because the very loan is an MSME loan. Because one of they got the paper just now only to give that. Okay. Yes. The application. Yes. She only brought today to me. I couldn't have. I only came with one copy. Then I got it.
We cannot.
No.
We are considering a petition on the basis of the document.
I'll file it.
We are not going to allow you to now tender additional documents, and we cannot pass an order on the basis of something.
Court of equity always. What has stood as second income is equitant, stricto jury, good judge always lean over equity. No. So this is the application. This is the habit I think.
Let it be over there. We are not disputing that fact. That the application
the very loan application is a MSME loan. The very loan is an MSME loan. Everything that's not in dispute. The very loan is an MSME loan. And I take your
note that. Is there anything else that you want?
Yes, now I rely on what their documents is. Their reply, my lord, at page 100. Their reply at page 100. Page reply, their reply. Bank's reply, not mine. Yes, you are relying only on you.
Yes, but what she is saying and what we are also saying is that is an admitted position. There is no dispute.
No.
So you don't need to argue that.
Yeah, that was one word, my lord, for my satisfaction. Classification. Udyam. Then smalls. It is therefore.
What is satisfied?
Yes. I'm sorry. So therefore, I am an MSME. There is nothing which I need to bring to the notice, but I did.
No difficulty. We recorded that. Anything else? Anything else?
Yeah, that.
Shall we give her a chance to argue?
Yes. I'm concluding in 2-3 minutes. Yes. Now I take your that on the 2 sentence or whatever on the law. This notification is mandatory, and that is what is the letter of the notification, and I'm entitled to a
Pronoun.
No. I'm not delaying any judgment, my lord. When the statute is in my favor, I'm entitled to a liberal interpretation, but I'm not asking for that. I'm asking at least literal interpretation, strict in like a criminal law. The interpret strictly. It is a preventive legislation. It is a remedial legislation. It is a welfare legislation. And if anything is there, one of the statute has to be read in my favor.
Yes.
It has to be in my favor. But I'm not asking for anything of the sort. I'm asking what the parliament has ordained in crystal clear words. And nobody is disputing the authoritativeness and the legality of this notification. This notification received the assent of both houses of the parliament under section 29, etc. I couldn't trace that. Power to make rules. every notification issued under section 9 and every rule made by the central government shall be placed before, etc. I am not reading it. So it will see the assent of the both houses of the parliament, and it is a statute. And now what is contemplated under the notification is a judicial tribunal, not a constitution.
We noted that, Mr. Edgar.
Yes.
Started your arguments
Yes,
with the same sentence.
Yes. And recovery, now, recovery is permitted. Para 543. Yes. Once and first two options, that is rectification and restructuring, are seen not feasible. New recovery process may be resorted to. The committee may decide the best recovery process to be followed. So recovery is permitted. Then the committee, I am not reading it. The committee is practically bank only two officers of the bank, one a subject expert and one representative
Your
of the.
submission is that there is no such committee.
No such committee has been formed by this bank,
Yes.
and for that matter any bank, and yes.
You cannot decide any bank. We are only just now.
This committee, yes, the committee has not been formed, and now therefore I take your lordship to one or two decisions.
Mr. Kumar, you said 2 minutes.
Yes.
You said 2 minutes 5 minutes ago.
Yes. I take a judgment of the Kerala.
Let us at this.
Yes.
Let us at least
My
hear.
lords may kindly see page 17, para 36, my lords of the petition.
Page.
17, para 36.
Yes.
It says, it has, the cause of action is explained, my lord. The petitioner submits that cause of action has arisen when 17/10/2024, and the petitioner received the 13-2 demand notice. 13-2 demand notice is after that, 2010-2024. Further cause of action arose on 21/10/2024 when the petitioner received a notice under 13-4. This notice is 8th January 2025, my lord. 13-5 notice, 13-4 notice for taking symbolic possession of the property on 18 months.
Are these on record?
8-1 is on record, my lord. 8-1 possession notice is on record.
Where is that?
Page number 84, exhibit P.
Page number 80.
4.
And this refers to the 13-2 notice of 21/10/24.
Yes, sir. It refers now. Initial para, my lord, first para.
Yes, please, sir.
Fourth line, my lord. 21/10/2024. It refers to that.
Yes.
Then, my lord, they have the parties to the present petition, my lord. I don't know whether they have served all others, but disjoinder of parties is there. Board of directors of Canara Bank is not required. Canara Bank is not required. Authorized officer I can understand because they have challenged the 13 for action over here. Then my third thing is the alternate remedy is available to them. This sale notice was never forming part of this petition, my lord. They have not amended the petition and neither approached the Honorable Learned DRT for seeking any reliefs or by filing essay or anything. Nothing has been done of that sort. Now, my lords, I would like to submit this judgment, my lord.
Which judgment?
And your case is that there is no response to 13-4.
No response to 13-4. I have said that in my written note. States and events, my lord. All
Have
these
you given?
judgments.
Have you given?
Yes. Judgment. Yeah.
The first judgment is Justice Datta's judgment.
Yes.
We've seen that.
Then, my lord, second is of Pronet. Yesterday I just handed it over. Now, third judgment, our High Court has also decided this issue with the similar prayers, my lord. All prayers are being recited in this judgment, my lord.
Which is that?
I will
Justice
provide-
Kolabawala's judgment.
Justice Kolabawala's judgment.
Page number
Page number,
21.
yes, sir, 21. And para numbers also I have given, my lord.
Which is the
Starting paragraphs are the judgments which are reproduced.
Mr. Nedumbara
26.
appeared in this matter? Yes, because most of the MSME matters,
Yes.
his name is always there.
And my lord, the fourth judgment is of our High Court, my lord. That is also Justice Karnik's judgment, my lord. Honorable Justice Karnik.
Yes.
Sorry, this is fifth judgment. Fourth judgment. Page number 41, my lord.
Yes.
The fifth judgment also reproduces all the prayers which are there, and all these prayers are similar, my lords, which are in our petition.
Mr. Nedumbara, you are appearing in all these matters.
Yes, let us complete.
My lords, in fact, the issue which he has raised, that bank has to consider this numbers, the incipient, that is well covered. Justice Andurkar's judgment is also there.
Swami, you are referring to
Page number 35, my lord.
Justice Chandorkar's judgment in Kamal Construction. Perfect.
perfect.
It's already been decided also. Page number 35, my lords, of my judgment.
Page 35?
Page 35, para 14. The word incipient means beginning to come into effect. The word incipient is taken from that circular method.
Yes.
Come into beginning or to become apparent. As per the Oxford Learner's Dictionary as well as the Cambridge Dictionary, the meaning of the word incipient is just beginning. Keeping in mind this meaning and coupling the same with the word stress, it is obvious that clause 1 of the said notification provides that banks or creditors are required to identify the beginning of stress felt by MSME in their financial capacity to repay. Considering the fact that there are thousands and thousands of MSMEs who have raised loans from the banks or NBFCs, such identification is impossible unless the same is brought to the notice of the bank by the MSME itself. After all, how a particular borrower is performing in its business and whether any such business is undergoing or beginning to feel stress or financial capacity is within the knowledge of the said borrower running the business. Unless such knowledge of incipient stress of a financial condition of MSME is brought to the notice of the bank, it is next to impossible in our opinion to be identified on its own by the bank or NBFC. So this is an answer to what he has argued. This clearly deals with all the prayers and issues, my lords, which he has argued and which are prayed in the petition, my lords.
Oh, is my friend finished? Yes. The reason why, my lord, I always can fortify that the judgment shall never be relied. That's always great difficulty make.
Because you are there in all the judgments.
No. I don't. I am on a campaign. Burn all law reports, the self-petition. Yes. It sometimes will work. Because, my lord, may take your lordship to page 63. Page 63 of the.
Of what?
That paper book. My son judgment. Yes. 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 No, I no longer practice as a lawyer. My role is as a reformer. Yes. But we make it clear.
I noted that.
That the observations made in this order are prima facie and do not want the statutory authority or tribunal to be influenced by our observations.
Yes.
Before whom the challenge to measures initiated by the bank are pending.
No, you pointed it out. I have noted that.
Yes, okay, grateful to Lord. So therefore, this is only doesn't bind anybody. It's only a prima facie opinion.
Yes.
Nothing is said conclusive. But if a prima facie opinion cannot bind the parties to the case, I am a third person. I have no opportunity to argue, counter, anything. How can it bind me? Now, the second statement is, yes, Manoj Ladwani, yes, right? Not Manoj.
49.
Start with Manoj Ladwani. This was pending on the 26th of June 2025.
What are you referring to?
Yes, Manoj, at this page 49. Sorry, my friend is referring to which element? Oh, sorry, Manoj Ladwani is not there. Sorry, I made a mistake. Alexis, sorry, made a mistake. Page 41. Page 41. 41. Yes. Alexis Business Solutions. This judgment was pronounced when? On 2nd of December.
This is Mulapawala.
Alexis, no.
This is Zamdar
No,
judgment.
sorry.
Justice Zamdar judgment, page 41.
Yes. This judgment is this judgment is prior to Ronit.
Yes.
Ronit came. The question was, this was the initial stage.
Yes.
Initial stage, not mistake. Initial stage, all cases were dismissed, and your lordship finds cases were dismissed on there's a judgment Kodak Mahindra versus Girna. It has been reported. There were so many judgments. Kodak Mahindra versus Girna, and their issue was Justice Sagar Melot. The issue there was between the two creditors, MSME enforcing as unsecured rights of unsecured creditor against X, and a bank as a secured creditor seeking to enforce his rights against the properties of X. The controversy was between two creditors, and before the amendment of section 26D was incorporated, MSME as a creditor had a primacy over secured creditors. And the discussion was that 26D had taken away that. It has nothing to do with the dispute between a borrower and a creditor. Yes. But your lordship will find that judgment has been quoted at least in 25 judgments.
Yes.
So that is, my lord, the calamity, the judgment process. So the Alexis all came much before, and all judgment was about this. Here is a man who has come with unclean hands. That is the finding.
Yes.
It was a mark copy. I can very easily find out. It is all about the petitioner's conduct. May I take your lordship to paragraph 19?
We are not concerned with that judgment.
Yes.
We are concerned with Justice Chandrakant's division.
Yes.
And we are concerned with the follow-up judgment of perfect interest.
Yes, I'll come to it. So I'm not laboring on Alexis coming there.
We are not concerned with that.
Yes. Now your lordship would now next judgment my friend has referred to is yes. What is it? This is third is my friend has referred to page 21.
No, page 35, Mr.
Yeah, page 21 has been set aside by the Supreme Court in Ronit. When 21, here Naveen Chandra has been set aside in Ronit.
Oh, will not that.
Yes, Ronit, because in here Naveen Chandra Ronit is also one of the respondents.
This has been set aside in Pronate.
Yes.
Ronit is there, yes.
Yes. They have been set aside by Ronit. Ronit is the last petition there. So he went as first petition there, that's all. So therefore, there is no point in making a reference to that.
You are right.
Then coming to what my friend has referred to is, which is the one other one. Yes. Sri Shantinath is. That is only told. Again, my friend has referred to page 8 is also the same
Yes, I
one.
think you've covered all of that.
No, that is the same thing only.
Correct.
Yes.
You covered that.
Yes. Then only judgment I need to answer is, my friend, Dibanga Datta's statement. That's only judgment. Yes. Now, Justice Dibanga Justice Dibanga Datta. Yes. This is Dibanga Datta's statement. At paragraph 8.
Yes.
At paragraph 8. Promise is a decision of a coordinate bench of this court holding inter alia that the notification is binding on the lending banks and secured creditors.
We've read this, Mr.
Yes, and I am not rushing your motion. Now, this statement has been interpreted by two high courts, Kerala High Court and the
Supreme Court has been interpreted by Kerala.
No. Now, the statute only can be interpreted. Now, we live in an era where we interpret the judgment also.
When the Supreme Court is interpreting,
No, it can't be
and then a High Court is interpreting.
No, the Supreme Court judgment has been referred to. Yes. Yes. My Lord, I take your lordship to the judgment of the Kerala High Court, where the judgment of the Supreme Court in Sri Sami Saman, which my friend has referred to as the first judgment in the paper book. Yes. Sri Swami Samat.
Mr. Kumar,
Yes.
single judge.
Yes. Then I am only saying that the single judge has referred to the.
No, it's followed pronouns, the judgment has followed pronouns.
Yes.
Tell us just which paragraph.
Yeah, paragraph 23. In fact, the court has extensively extracted from the at page 21. At page 21, the court went on to extract from it page 16, paragraph 21.
Para 21 and para 23.
21. Let me read a few sentences from there. On a consideration of the rival conventions, at page 16, paragraph 21. On a consideration of the rival conventions, it is to be noted that the specific convention of the petitioners is that the respondent bank was statutorily bound to comply with Exhibit P3, that is the notification dated 29/5/2015, and P4 is the notification of the RBI dated 17/3/2016, which mandate that before classifying an MSME account as NPA, bank must identify NCP and stress in the account by categorizing it as SMA0, SMA1 or SMA2, and thereafter constitute a committee to formulate a corrective action plan. However, they failed to adhere to it, resulting in a clear violation of the notifications above. And the law laid on in Bonnie's section, then the court extracted from the Bonnie.
The relevant paragraph is 23.
So, 23, yes, 23.
We read that.
Yeah, I'm coming to it.
We read that.
Yes.
Okay, anything else?
No, now, may I read one for my satisfaction?
No, as it. Well, you said 2 minutes, now we'll give
Yeah,
it.
now coming to paragraph 26. Yes.
That's on track.
To this convention, the bank has merely stated that the petitioner's request was considered by the.
So, Mr. Raghunath, that is, we have not set up the committee, that.
Yes, and it is said no committee was ever constituted.
Yes, correct.
Agreed, yes.
Any other
Now,
paragraph? Tell us the
then
next
my lord, about the maintainability of the petition, paragraph 29.
29, all right.
Paragraph 29, then let me read, as regards the maintainability of the instrument petition, it is to be noted that classification of an account as an NP is a distinct and preliminary act having serious civil consequence, more so when it is in the breach of the judgments referred to earlier, besides the notifications concerned. As it, the classification of the account of the first and the second petition is clearly irrelevant.
We've seen that.
Yes. Now, my lord, paragraph, then the, yes. Now, last paragraph. What the court is.
We have the benefit of somebody's underlining also.
Yes.
Whatever I presume that you want us to read is underlined, and we will go through this.
And now,
There is a compliance with the notification that we.
and then now, a certiorarified mandamus was issued. For the last sentence, my lord. Yes.
The findings of.
Consequently, there will be a direction to respondents to comply with Exhibit P3 and P4 notification, last page 28.
Yes, sir,
Yes,
sir.
As well as first and second petition is concerned, and only after the third complaint. Now, then Madras report. Yes.
In Karthikeyan's judgment, what is
Yes. Karthikeyan judgment, the court found that, yes, no committee was ever constituted.
We've seen that also.
The Lordship has seen. Yes, we've seen this. And found fault with, then the court has even said, invoked Shakespeare, Shylock.
It's Shylock, not Shakespeare.
It has, then there are two issues. Since the issue involving a jurisdictional question, not relegated in the DRT doesn't have it. It has not been elaborated much. And second, the court took notice of that when you have not constituted the committee, it is not proper to say that you did not apply.
We've seen that, yes, sir.
And thirdly, my lord, yes.
This Madras judgment is.
Yeah, and it all discuss about the legislative intent.
Yes.
Thank you.
Great reply.
These are.
Yes, it is great reply.